if you, the employer, have been sued by your former employee for wrongful termination or discrimination or retaliation or maybe unpaid wages or any other type of claim that employees often bring against their employers in California, you need to make sure that you look not only at the theoretical, at the legal aspects of the case against you, but you also consider just as seriously the practical reality of handling that case. And let me tell you exactly what I mean by that. It is easy to look at the case that was brought against you, the employer, against the company, and say that I didn't do anything wrong, there is no case here, there is no discrimination, there is no wrongful termination, I am not paying a dime. However, the practical reality of handling lawsuits by employees necessarily involve certain inconvenience to you and certain and often significant expenses, even if you end up winning that case in the end, and even if that employee gets nothing in the end after everything is said and done. Therefore, when you're being sued, the first thing you need to do after you've been served with a claim or with a lawsuit, you need to sit down with your attorney and look at the entire situation in its totality. You shouldn't just be looking and discussing the legal theory of the case. Is there enough evidence against you or isn't there? You also need to talk about how much it's going to cost you to defend the case, even if you win. What's your worst case scenario? What is it going to cost you if you lose? And there's almost always a chance to lose one claim or all claims. You simply cannot know for sure what's going to happen. You have to have a candid discussion with your attorney. And while your attorney cannot guarantee you results one way or the other, and he might not be able to tell you exactly how much the process is going to cost, whether you win or lose, you still have to have a range of the risk that you're taking and the risk of exposure. You also have to ask yourself a very fundamental question. Is it strictly a business decision for you? Are you trying to minimize the expense and get rid of that case for as little money as possible? Or is it a matter of principle to you where you say, you know what? I don't care how much it's going to cost. I'm not paying a dime. I didn't do anything wrong. I don't want to set any type of precedent that I'm paying anyone for anything unless I've done something wrong. In most cases, the former approach is more prudent, while the latter approach, while it might sound very idealistic, very ideological, it might turn out to be simply not the wisest option. But it all depends on the circumstances, and in the end, you as a client, you as a party, it is your choice how to proceed. You should not hesitate to ask your attorney for their advice after they look at the case. Tell them, what would you do if you were in my shoes? This is my business. This is the size of my company. This is how much I make, or these are my assets. These are my risks. These are my obligations. This is how I feel about this case. This is how I feel about that employee who sued me. What should I do? What is the best thing for me to do under the circumstances? And you should necessarily take that into account. And once you talk about that, once you figure out what your goal is, you can proceed accordingly. It is also important to try sooner than later to find out what the other side, what the employee who filed a case against you wants. Many employers just start fighting and they don't even know what they're fighting over. They don't know if the employee who sued them wants $5 million, $500,000, or $100,000, or $10,000. So it's a good idea shortly after a case was filed against you to ask the other side through your attorney, hey, what do you want? Can you make a demand? Can you tell us how you arrived to that number? What is your claimed wage loss? What is your claimed emotional distress? Once you find out what they want, you can make the right decision about your strategy in the case as an employer. Should you forget about settlement negotiations because you're so far apart that you just have to fight because you have nothing to lose? You can never be anywhere near what they're asking for. Or is a demand more reasonable, where you're thinking, you know what? We're a little bit far apart, but we're not too far apart. I think we could continue talking, continue negotiating. Maybe we could go to a settlement conference or to mediation sooner than later and try to shortcut the process. At least it's worth a try. At least it's worth a shot. So these are critical questions early on before you incur all the legal costs and fees. So keep these things in mind if you're served with a lawsuit or if you're served with a claim for unpaid wages, and it should put you on the right track toward resolving that case. Thank you.